Good evening. Warm welcome to all of you who have joined us here today, this afternoon. I am Deni Manzari. I'm an associate professor in competition law and policy at the faculty and one of the editors of Current Legal Problems. And this afternoon, I have the privilege and the pleasure of hosting here today Dr. Orla Lynskey, associate professor at the LSE, who is delivering our CLP lecture, and Mr. Wojciech Wiewiórowski, the European Data Protection Supervisor, who traveled from Brussels to chair this lecture on effective or complete data protection. I shall say a few words about our chair this afternoon. Mr. Wiewiórowski was appointed by joint decision of the European Parliament and the Council on 5th December 2019 for a term of 5 years. Before his appointment, he served as Assistant European Data Protection Supervisor from 2014 to 2019, and as an Inspector General for the protection of personal data at the Polish Data Competition Authority, a position which he held since 2010. He was also Vice Chair of the Working Party Article 29 group. Thank you very much for joining us this evening and for traveling from Brussels to chair this lecture. And without any further ado, I'll pass the floor to you to introduce our speaker this evening, Dr. Orla Lynskey.
Thank you very much. I'm really honored and really privileged to be here with you tonight. That's true that I traveled from Brussels especially for this lecture, but this is because of my respect to the work that has been done by Orla Lynskey last years as far as data protection is concerned, and the global approach, the European approach, and the national approach to this matter. This is also my honor to be here in the UCL and meet all of you. I see many familiar faces in the audience, the professors and the researchers in the field of privacy protection. I'm introducing Dr. Orla Lynskey, who is globally respected source of thought, source of ideas for the data protection world. Dr. Orla Lynskey is an associate professor at the Law School of London School of Economics. She's also visiting professor of the College of Europe in Bruges, in Belgium. She holds several law degrees from the Trinity College Dublin, from the College of Europe and the University of Cambridge. She is an editor of the specialist journal International Data Privacy Law, and a member of the Modern Law Review Editorial Committee. She's an author of the book Foundations of the European Data Protection Law, which was one of the main stones at the time when we were discussing about the new data protection regime in the European Union. And she authored numerous peer-reviewed articles with particular focus on regulating powers in the digital economy. She's also in the program committee of the Privacy Law Scholars Conference, which drives me to her academic work. But we have to also remember that she plays an important role in the policy making. As the advisor of the European Consumer Organization on Consumer Protection 2.0, and she was also an expert of the OECD committees, of the Joint Parliamentary Commissions in the UK and in the European Parliament, and also for the Federal Trade Commission. Dr. Lynskey's research interests lie broadly in the technology regulation, digital rights, and EU law. These fields of interest also speak very much to me as the data protection regulator, because the European Data Protection Supervisor is the supervisor of the EU institutions, bodies, and agencies. So we are not only advising in the legislative process, but we are also the supervisors and the regulators. And Dr. Lynskey often witness a reality where the technology regulation is increasingly intervened with digital rights, which are increasingly affected by the EU law. Data protection is becoming a challenge, and today's lecture will be about this challenge. We see this is not only the EU, where the emergence of the new legal acts call into question the key data protection principles. And we are asking ourselves, are we starting the discussion again about the foundations of the data protection? Or we are only discussing about interplay between something which is fundamental right in the European Union and the other policy and right landscapes that we have at the same time. Because we do need to ask ourselves whether it is possible for the law to be effective with being complete, whether it can seek to fulfill the promise it makes to protect the fundamental rights of the people. I often say that we are not protecting the data, we are protecting the human beings. And this is something to remember. So we are looking at the technology, but we have to see the person over that. And with that, I give the floor to Dr. Lynskey, who is also close interlocutor for the EDPS. The European Data Protection Supervisor has worked numerous times with her. She was taking part in our projects like Digital Clearinghouse, which was dealing with the data protection and competition law at the same time. And recently, she was the speaker at our conference on effective enforcement of data protection law in June 2022. Thank you once again for the invitation to this lecture. But today, the hero is Dr.
Good evening, everyone. First of all, let me thank the Data Protection Supervisor for this very kind introduction, but also for doing me the great honor of accepting the invitation to chair this evening. I really appreciate that support. Thank you also to the editors of CLP for entrusting me to deliver this lecture. I also appreciate that support. And in particular for Dr. Deni Manzari, who's provided a lot of guidance throughout the process, and to Emma Blackman, who has seemingly infinite patience for all of my organizational queries. And of course, thanks to you all for being here this evening. I appreciate that data protection is not really a subject that people think about as kind of getting pulses racing, but I think that's wrong. And I want to show you why this evening. So, as we've already heard from the Data Protection Supervisor, data protection exercises or has quite a privileged position in the EU legal order. It's part of the Charter of Fundamental Rights. Article 8 of the Charter has an independent right to data protection in addition to a right to privacy. Other EU legislative instruments are looked at as being without prejudice to the General Data Protection Regulation, especially if we look at recent instruments adopted in terms of digital regulation, like the Digital Services Act and the Digital Markets Act, which seems to put data protection as the kind of cornerstone of policymaking in this area. And then if we look beyond the EU's borders, we see that the EU model has been used, and the European model more broadly, has been used as a blueprint for the development of data protection laws globally. And so in this sense, data protection is, as I said, both kind of a cornerstone of EU digital regulation, but also a kind of a poster child of digital regulation. But set against this success story, I think that when you look at the literature, we increasingly see reservations being expressed about the scope of application of the data protection framework in particular. And so I think it is credible to suggest that data protection now, as Nadia Portova has stated, is the law of everything. And tonight I would add applied to everyone. And this has been as a result of the jurisprudence, in large part, of the Court of Justice of the EU. And the jurisprudence has developed in this way because, exactly as we've heard, from the early days in which data protection legislation first was developed in the 1970s to now, we have a very different socio-technical context. The data protection framework was developed at a point in time where there was little or no personal computing, and where the main concern was about automation and the impact of data files on the individual's personal rights. And so earlier forms of data protection, for instance, spoke about controllers of the file. But this is kind of a far cry from where we are now with personal computing, the internet, smart homes, smartphones, etc. And what the Court of Justice has tried to do through its case law is to expand the regulatory scope of the law to continue to protect fundamental rights in the face of technological change. And it has done this under the kind of slogan or mantra of providing effective and complete data protection. But the problem I want to assess this evening is whether or not we can have both and whether or not the complete scope of the law, by drawing out what the law applies to, in fact, might endanger the effective application of the legal rules. That is precisely what I want to talk about. So just as a bit of an overview, I'll start by talking about the jurisprudential developments. So how did we get to a point where I think we could say data protection is the law of everything applied to everyone? What this means in terms of providing, as I said, complete and effective protection. And so here I want to try to identify in particular the ways in which the law's broad scope, in terms of who it applies to and what it applies to, challenge, in essence, its administrability. And I'll identify some key challenges there. And then I'll start to highlight what has been the response so far, which I think is a kind of a patching over of the cracks in the system through the exercise of kind of a lot of judicial rationalization of the law, and by regulators, the exercise of discretion to try to kind of make the various pieces of data protection law fit together more coherently. But before I do that, I want to, because I'm not sure who's in the room, go over a little bit about the nuts and bolts of data protection law and the dynamics of how this law works as a system. And so the first thing to note is, as I've said, in the EU context, we have this fundamental right to data protection. And what's odd about data protection law is that it's said to give legislative expression to this fundamental right. So we know what the fundamental right is by looking at the law itself. And the way the law is structured is that it has this extremely broad scope of application. And then once you fall within the scope of the law, you can kind of justify data processing by complying with certain obligations and where data subjects, us, individuals, have certain rights. And so in this sense, if we think about it from a kind of a fundamental rights logic, what the Court of Justice of the EU says is that every act of processing personal information, and I'll kind of go through these terms later, but every act of using personal information is an interference with this right. And in order to justify that interference, you need to have compliance with the legal framework. So you can see that the whole legal framework acts as a justification for the interference with a fundamental right. So once you're within the scope, as I said, we have obligations imposed on so-called data controllers. You're going to hear a lot more about those this evening, and rights which are given to individuals, data subjects. What's interesting, perhaps, is that the obligations imposed on controllers are both general principles, like fairness, but also quite prescriptive requirements, very detailed transparency requirements, for example. And these all apply ex ante, before you start to use the data. So things like the determination of the purposes for why you're going to use data. And then this is backed up by a system of demonstrable accountability, where you need to, as a data controller, record your thinking before you start data processing, write this down and engage in record keeping, amongst others. In terms of the rights given to individuals, we have things like a right to access our data, a right to object to data processing, a right to data portability. We have a whole kind of suite of rights available to us. And again, though, these rights are backed up by both private enforcement and so before the courts and public enforcement by regulators. And the existence of independent regulators is looked at in Article 8.3 of the EU Charter as an element of the fundamental right to data protection. Okay, so kind of armed with that knowledge about how the data protection system works very broadly, why do I say it's the law of everything? Well, when you look at the law, you see that we have these very broad definitions of processing, which is any operation you do with data. It's a little bit more nuanced there, but let's take that for the moment. And what becomes critical then is that the processing has to be of personal data. And here, personal data might not kind of be similar to what we might intuitively think of as our personal information. Personal data is instead defined as any information that relates to someone who is identified or identifiable. And so if you have personal data processing, the law applies. There are very few derogations. There's one for purely personal or household processing, but this has been construed extremely narrowly. So if, for instance, you as an individual upload, if I took a photo of the room and uploaded it to Twitter, I would be personal data processing and no longer able to benefit from this exemption because I would have made the information available to the world at large or to an indefinite number of people. And so let me come back to the idea then of personal data, because a lot hinges on this. And this is what Portova calls the law of everything, or what makes data protection the law of everything. So if we took an example that is very close to home, something like whether an exam script constitutes personal data, the answer from the Court of Justice in the Novak case is yes. And it reasoned as follows. It said the exam script, plus beware, the comments of the examiner are information. So it doesn't matter whether or not the information is true or false. It doesn't even have to be particularly meaningful information. So in Novak's case, it was an accountancy exam, like not exactly a window into his soul. So it has to be information that it was said to relate to him because it was either about him or linked to him as a result of its content, its purpose, or its effect of processing. And here the court reasoned, well, because the use of this exam paper would have an impact on his future job prospects, for instance, that would be sufficient for it to relate to Mr. Novak. And he was, of course, kind of identifiable because even though he was writing under an exam number, somebody could reasonably link that information back to him, the data controller or somebody else. And that's the test in the law. So an exam script becomes personal data subject to the framework. This picture here, the kind of happy clappy picture of a street is stratum signed in the Netherlands, in Eindhoven, where Portova takes the example of rainfall data that is collected as part of a smart city project. So stratum signed is meant to be a very popular social street, a lot of antisocial behavior apparently. And so the city, in its wisdom, entered into a public-private partnership in order to try to reduce criminality by installing cameras and sensors across the street, to take pictures of those who were present on the street, and also to collect all kinds of other data that might be relevant to whether or not criminal activity would occur. And they surmise that weather data could be relevant here, because if it's raining, then fewer people might be out, and then you might have less likelihood of criminal activity. And so Portova says, well, this weather data can then be personal data because it's information. It can be used to impact on someone to determine whether or not, for instance, they are stopped or searched or apprehended in some way by police authorities. And it relates to someone who is identified or identifiable, because by combining the various kind of sensor data that was available from all of these cameras and devices, you could link this back to an identifiable person. So this might seem absurd, but I think why data protection bites here is because you are using information to impact upon or to exercise control in some way over an individual. And so there's a question here about whether or not, that's an appropriate application or interpretation of the law. But this becomes even more complicated because the law and this framework applies to pretty much everyone. So A data controller is defined in the law as an individual or an entity which alone or jointly with others determines the purposes and means of processing. So a data controller is basically the intellectual lead on a data processing operation. So any use of data, they determine how data is processed and why. And here the law has complete horizontal application. So this is individuals, it can apply in interpersonal relations. And you can see also that the law doesn't necessarily distinguish in any way between me, Orla Lynskey, and a tech giant like Meta, for example. We both fall within the scope of the law. What we see, though, is even though the rules were designed in a technologically neutral way, the way in which we conceive of a data controller, so kind of a single entity determining the how and the why of processing, doesn't map in any way neatly to the kind of networked data processing operations that we see in the current digital environment. And this starts to become apparent in the case law of the Court of Justice in the Google Spain case. So in that case, substantively, it was about an individual's right to have information delisted from Google's search engine, but that right to delist would only kick in if we considered Google to be a data controller. And so Google, for his search engine activities, said, well, when we provide links to content on Google's search engine, we don't have any knowledge or awareness of whether a link is a link to information about an individual or not. We do this, we provide these links irrespective. And the court said that we need to take a literal interpretation of the law, and that by providing these links, Google determines the purposes of processing to make information and links available to individuals, and the means of processing, how that's happening. And so Google is made a data controller. It justifies this, or kind of places a slight caveat. It justifies it by saying we need to have effective and complete protection of individuals. And it introduces this formula that proves to be quite important in subsequent cases, so that Google only needs to comply with the law within the framework of its powers, its responsibilities, and its capabilities. So the law applies, but we have a hint that somehow there'll be a rationalization. Then there are a whole series of subsequent cases where the court was asked to determine how much control precisely over data is needed for an entity or an individual to be looked at as a data controller. So in this Fashion ID case, for example, Fashion ID was a website that on the website had the Facebook like plugin embedded on the website. And so when you visited the website, an individual's data was directly transmitted to Facebook. Fashion ID had no access to this data, but the court held that Fashion ID was jointly responsible for this processing. Why? Because it kind of facilitated the data processing in the first place. It acted as a kind of a honey trap for individuals to visit the website, and that then made it possible for the data to be transferred to Facebook. And so it said Fashion ID therefore exerted decisive influence over the processing. It derived a mutual benefit from the processing, and it didn't matter that Fashion ID never had access to the data in any way. So this kind of mediating role was looked at as sufficient. And then finally, and this came kind of before Fashion ID, but is perhaps most, I'm glad my first attempt at a GIF has actually worked. This came before Fashion ID. We have a kind of an intriguing case involving the Jehovah's Witnesses, where the Jehovah's Witness community obviously encourage their members to go out and preach on behalf of the community. The community itself doesn't give any written guidelines on this. It simply kind of verbally and informally tells the members more or less what to do with the data. And so the members have total control over what data they collect, in what circumstances, how they collect the data. And the data then is used to create a refusal register, so a list of people who don't want to be visited again, for instance, and used in that way. And in this case, citing Veal, the Jehovah's Witness community essentially plays a kind of an orchestrating role in relation to the data. So the court says here the community organized, coordinated, encouraged the preaching activity here. you couldn't really say it exercised any meaningful control over the data in these circumstances, but that was enough for it to be held responsible. So you can see that the law applies to everything and potentially brings everyone within its scope. And there have been kind of some misgivings about this expressed in the literature. So from within the court, Advocate General Bobeck has been quite frank about his misgivings about this approach. He says simply that the court has not been faced with the sweeping practical implications of this definitional approach. Bygrave and Tassoni say, well, while the law gains an enormous scope of application here, this is perhaps beyond what it can actually cope with in terms of enforcement and in terms of compliance. Nolan says, the assumption here underpinning the court's approach is that by having more actors within the fold, we'll have better protective outcomes, but that's not necessarily a sound assumption. And Coops is perhaps most damning. He says that this makes data protection a kind of a dead letter, meaningless law on the books. And so, as I said, this, I think, leads us to question at least whether or not the law can be both effective and complete. And so it turns out that trying to assess the effectiveness of a regulatory instrument like the GDPR is extremely difficult. And so if you looked, for instance, at the human rights literature on assessing the effectiveness of fundamental rights, somebody like Grania de Borca says, well, we need to take an experimentalist approach to this. And we can look at the extent to which civil society actors are engaged in a way that kind of brings about reform at the ground. And so if you looked at it in that way, well, we've had some very high profile success stories for data protection law. Digital Rights Ireland, Max Schrems' cases around data transfers, and various others. But that seems to be a very partial account, more of an account about how effective the right is rather than the legislative framework. And so here I think we need to go to the regulatory literature, which would say to assess the effectiveness of the regime, we need to look at its objectives and whether or not they are successfully achieved. And this is where things get really tricky. Why? Because immediately, if you look even at the wording of the GDPR, you see that in Article 1, it's designed to, on the one hand, enable the free flow of data, and on the other, to protect the fundamental rights of individuals, in particular data protection. What is the right to data protection, you may be asking? And to that, I would say we have various responses. Some people say it's about individual control over personal data, informational self-determination. If that's the case, the law has manifestly failed, because I don't think any of us could honestly say we have control over our personal data. If it's about fair processing, we could say, well, do we mean procedural or substantive fairness? And how do we interpret fairness in this context? Others say it's simply about putting in place procedures for data governance, a kind of a right to a rule. But this strikes me as implausible, because then the right doesn't really have any substance. It can be changed by whatever rule comes next. And others simply say, well, like the right to privacy, it's instrumental to the achievement of lots of other rights, lots of other fundamental rights. But this is problematic, because if we are trying to, for instance, apply a purposive interpretation of the law, we are doing that without a clear understanding of the law's purposes. So how then, kind of keeping that in mind, do we know whether or not the law is doing what it's supposed to do, achieving what it's supposed to achieve? Well, the fundamental rights logic I mentioned earlier would say, if every act of data processing is a breach of the right, then the mere act of complying with the law would mean that that breach is justified. The law provides the justificatory framework. So we'd simply say, the right is effective if everyone is complying with the law. Well, I think there are kind of two immediate issues with that. So first, we're assuming that the rules are the right rules, which is increasingly called into question. And then perhaps more practically, we're having a lot of difficulties in trying to figure out, well, what's the right empirical measure to determine whether or not there's compliance? Is it the number of complaints that are received, for instance? And would that be a measure of success or failure? Is it the number of rights that are exercised? Is it changes in market practices and mindset? We could imagine various different empirical measures for success. So what I'm doing to kind of avoid these pitfalls is simply pointing out the compliance challenges that I think already, from a conceptual perspective and from a practical perspective, present when we have such a broad scope of application. And here I think we have three significant challenges. So one is this kind of mismatch between the technologies that we see now operating around us and the way in which the law assumes those technologies operate. Another is the fact that this joint controllership has kind of segmented responsibility in a way that makes the law practically impossible to comply with, even with the best will in the world, a kind of a marker, according to Fuller, of a bad law. And third, that we have such a diversity of regulatees, of targets of the law, that it inhibits the development of what Julia Black calls interpretative communities, who all have a kind of shared understanding of what we want the law to do. And this is pulling regulators in competing directions, where again, for regulators, it's simply not possible to meet all of the competing demands put upon them by this broad regulatory framework. So let me go through these in a little bit more detail. Sorry. So on the disconnect between the technology and the law, and here Roger Brownsword and Goodwin talk about a regulatory disconnect occurring where the law on the books simply can't apply to the technological realities around that we're surrounded with. And they talk about a disconnect between business models and the law, but here I don't think it's necessarily about the business model in this example, more about the technology itself. And so I said that Google search engine was looked at as a data controller in Google Spain. Now, already before that case came to the court, the advisor to the court, the Advocate General, had warned that this would make compliance for Google actually impossible, that it simply wouldn't be able to meet its legal obligations. And this came to a head in a case called GC and Others, where the question was how, when Google lists to links to articles, to URLs on its search engine, what happens when those URLs contain sensitive personal data, so called special category data under the law? And if you look at Article 9 of the GDPR, you see that it just contains a full-on prohibition on the processing of sensitive data. So this is things like medical data, biometric data, genetic data. Now, obviously, there are some exceptions to this, but none of these apply to Google's business model or technology. And so this looked like the case where we would finally kind of bring these things to a head and say, well, Google's business model is incompatible with the law. The court, however, says that this prohibition applies to Google via a verification under the supervision of the competent national authorities on the basis of a request by the data subject. So take a minute to read the wording of the law and ask me, or answer for me, how we achieved this. So you can see that not only have we kind of departed with the need for a literal interpretation of the law, but also that doesn't in any way correspond to the general scheme of the law, because we have a whole section dedicated to rights of the individual, and this prohibition is not in that section. And so what I think we see here, maybe you could make a parallel with the rule of reason in competition law, is a kind of an ad hoc rationalization of responsibilities. And so De Gregorio says, well, this is needed as a safety valve against the disproportionate extension of obligations. Whereas it could otherwise be argued, well, this is an unprincipled application of the law, perhaps justified because a lot of people love Google search engine, but to accommodate that particular technology in these circumstances. And what is perhaps more concerning is that the court justifies this on the basis of that responsibilities doctrine that I mentioned earlier, that this here is what is required because this is what falls within Google's powers, capabilities, and responsibilities. But I think as a lawyer interested in technology, this raises a lot of questions about the way in which we're shaping the application of a general law to deal with a specific and to accommodate a specific technology here. It also raises the prospect that others will design their technologies in ways which makes compliance with the law impossible in practice. And so it kind of creates an escape route from the application of the law that probably wasn't intended when we wanted effective and complete protection. The second issue is one of practical impossibility of compliance. And this was raised by numerous authors in the literature, but I think most vividly illustrated in a piece by Matthew van Hobach and Anne Ashgari, where if, for instance, if you think of that fashion ID case that I mentioned, where an individual visits a website and the website has the little Facebook plugin, and that means the individual's data is transferred to Facebook, that website, as a joint data controller, owes you all of the obligations of the law, including, for instance, an obligation of transparency. And that includes telling you what the purposes of the data processing are, who the data will be transferred to, what the end game with the data is really. And Matthew and others kind of highlight, well, this simply isn't possible for the website to do. The website's transferring the data to, for all intents and purposes, a black hole. And so they say, what would a transparency notice look like here? Well, we collect your IP address and browser ID and transfer this personal data to Facebook. We don't know what Facebook does with the data. Click here to proceed. And so this is one of the many examples of situations then where the law becomes practically impossible to fulfill on the ground. And then maybe final thing to note in terms of the compliance challenges that this leads to is around the diversity of the regulated community. And so, as I mentioned here, Julia Black in her work on rules and regulators says that successful regulation typically benefits from having a cohesive interpretative community. And this means that those who are targeted by the law have some sort of common understanding of the terms of the law. And this can be used to kind of avoid situations of under and over compliance on the part of regulatees. And I think when you look at data protection, we often talk about the kind of under compliance with the law, but we also see a lot of examples of over compliance with the law. As people will know, if you've called a utilities operator when you have a joint bill, for example, or I think my personal favorite still remains the Irish Data Protection Commissioner in Ireland having to inform the General Post Office in Ireland that it wasn't contrary to the GDPR for it to leave its post or its bins outside the post office. And so you could see there how the diversity of the interpretative community meant that people didn't really understand how this legislative framework, which is extremely technical, in many places very prescriptive and full of terms that might not be intuitive, applied to them. And so here we could say, well, bringing everyone within the fold might make this more challenging. So if we narrowed the scope somehow, even removing individuals from the scope, then this would assist in constructing the meaning of vague terms. And we would see that some provisions where it's kind of awkward to apply them to individuals, like the very detailed list of transparency requirements that you have, don't really apply very well in interpersonal contexts. Again, if I took out Article 13 of the GDPR, having taken a photo of this room and started to read to you all of the requirements, that doesn't seem to match the context appropriately. The kind of other side of this is that regulators are left dealing with a huge variety of issues. They're dealing with systemic issues in kind of data-centric industries. So things like online behavioral advertising or kind of surveillance-based advertising, and trying to kind of get to the bottom of that. They're looking at and regulating the public sector when they use personal data and things like national identification systems. You have a lot of complaints by individuals against enterprises. So about 40% of the complaints that are dealt with are simply subject access requests, kind of appeals. And then we also have situations of interpersonal complaints. So for example, in the UK, We have the case of Fairhurst and Wakefield, which is an extremely entertaining read about some neighbours in Oxford who got in a dispute because one neighbour had installed a significant surveillance apparatus in and around his house, including things like a Ring doorbell, which can capture audio up to 20 metres away, and which brought you to Fairhurst's front door, basically. And so here, the data processing in that case was deemed to be illegal. But you can see that the data protection regulators would also then be brought into these types of disputes. And I don't think we can say that they're not properly the kind of purview of data protection law as it's currently framed. So what then should we kind of take from this? Well, we could just continue with the status quo. We could kind of ignore this mismatch between the law and the books and practice, kind of comment on it and move on, continue with business as usual. The other option, I think, is if you look at what's happening on the ground a little bit now, and if you look at the regulation literature, you see that the recommendation is for kind of over-inclusive rules to be applied in a way that takes into account site-level flexibility. So in their work on unreasonable regulation, Bardak and Kagan say that where you have a very inclusive rule, which risks being over-inclusive, you might want to mitigate that by applying kind of what they call site-level flexibility. And again, Black kind of says, well, this is about, you might kind of compensate for over-inclusion by having a kind of a reflexive relationship between the scope of the rule and its enforcement in practice. And so we could imagine this kind of playing out in two ways. So one might be in determining whether or not there's an infringement in the first place. And so you could say, well, if data protection is a fundamental right, then so much of its application should be about proportionality. And so, the court could reconsider its jurisprudence on this basis. Seems highly unlikely. And also, a lot of this is now consolidated in the GDPR itself. We could say that if you look at the principles in data protection, or the kind of fair information practicing principles, we have an opportunity for proportionality there. So I think that's possible, but it doesn't get us away from, there's no reading of the prohibition on sensitive personal data processing, for instance, in a proportionate way. So then you might say, well, what about proportionate enforcement? And here, if you look at the law, you see it says that regulators must handle complaints and investigate them to the extent appropriate. So this has led to a lot of contention about the extent to which regulators must reach final decisions for each and every complaint that they receive, or whether or not there's an option for them to, and it's not expressed in this way, but essentially to follow the Ayres and Braithwaite responsive regulation enforcement pyramid, where you start with a bit of a conversation and then you gradually kind of escalate enforcement, the more problematic or the less successful that approach is. And if you look at the law, the wording around administrative sanctions is not entirely clear, because it says you don't need to impose administrative sanctions, keeping in mind, which I should have highlighted earlier, the administrative sanctions here are up to 4% of annual global turnover for an enterprise, so quite hefty. You don't need to impose such sanctions on individuals where it will be disproportionate, or for minor infringements. So we might, and regulators seem to be, starting to think about this. On the other hand, as lawyers, we might highlight some of the challenges of applying that kind of site-level flexibility in this context. So first of all, proportionality requires us to think about whether or not something is proportionate relative to a particular purpose. And so the lack of clarity about purposes kind of detracts from the ability to use proportionality here. We might say that this kind of departs then from the equal protection and equal application of the law, and that won't be sufficiently clear. So there are very few actually, but some articles arguing that responsive regulation is incompatible with the rule of law. We could see here significant accountability issues on the part of regulators, where this practice won't be apparent to individuals who are claiming their rights under the data protection framework, their fundamental rights, and where a kind of a silent jurisprudence is building up around the application of the law. And of course, this conversational approach is inappropriate in some circumstances where there's a risk of immediate harm, where you're dealing with companies that have shown themselves kind of unwilling to engage in an appropriate way with the regulator, for instance. There are some other conditions that we might think about applying. But I think the big problem with this is that under data protection law, even if regulators acted in this way, private enforcement for breach of the law is still there in the background. And so that might seem kind of speculative, but we could imagine situations where if an individual didn't get a response they wanted from a regulator, that they went before the courts to have a go in that way. And these two things are not looked at as mutually exclusive. So kind of wrapping up, what you can see is that, for some, data protection is simply a broad church. For others, it's been described as an indiscriminate obsession. But there are a lot of challenges that arise from having this law, which is applicable to everything. I don't personally disagree with that. I think it might be justified, but also applicable to everyone, because I think a lot of these challenges arise, in fact, from responsibility under the law. And so this means that the law is being pulled in different directions. It's harder to keep this law that was designed for controllers of the file in the 1970s and has been kind of added to in various iterations over the years. It's making it harder to keep it all together under this one umbrella. There's a challenge to interpret the law in a way that is coherent or consistent across all contexts. And there's a challenge for regulators to deal with a lot of the pressures that they are required to handle, because they must, unlike other administrative agencies, deal with these complaints, because individuals have a fundamental right to have their complaints dealt with. So they're not able to exercise discretion like in other areas. So what might we then, conclude? Well, turning to the future, as you might expect, I don't have a solution to this problem. But some things do become apparent in the analysis. So one is around the lack of empirical evidence that we have about how the law is actually working. So here, Bamberger and Mulligan in the States have said that this lack of empirical assessment leaves legal reformers shooting in the dark without a real understanding of the ways in which previous regulatory attempts have either promoted or thwarted privacy's protection. Now, Ari Waldman in the States has done recent work on kind of privacy on the ground. In the European context, David Erdos has done this work in journalism, and Maria Magierska at the EUI is speaking to regulators about how they see their roles evolving. So the scholarship is coming through, but for the moment we are shooting in the dark. The other thing we could say is no law is fully enforced. And so complete scope shouldn't require complete enforcement. And yet I do think we need to have some sort of benchmark in mind for when we would say, well, the law is no longer fit for purpose. At what point would we say that there is a kind of a failure of the law to protect fundamental rights in this context? And maybe a starting point, if we are to reconsider, is to go back to the purposes of the law. And I appreciate the supervisor's point that, this kind of begs the question of, in data protection, whether we go back to the roots again. And I think if we did do that, a big question to start with would be how and whether we want to kind of disentangle informational privacy, those kind of interpersonal disputes, for example, and kind of core privacy concerns from broader concerns about fair data processing in a networked, digitized society. And just as a final word, I will leave this to Spiros Simitis, who is one of the kind of data protection pioneers, who says that this task of kind of achieving a balance between harnessing and benefiting from new technological developments while protecting fundamental rights is burdensome and complicated. But he says data protection was, after all, from its earliest days, an impossible task. And so that sounds, perhaps, I find that quite optimistic, but others might see that as quite fatalistic. But here I think he was being quite realistic. He looked at data protection. He also referred to it as an unending learning process. And I think it's kind of in that spirit that we need to approach this question of how to have effective data protection going into the future. So, thank you.